и развивают эти направления среди студентов и молодых специалистов. А мы проводим конкурс «Лучший по праву» вместе с ведомостями. Старшая Женя Червец, ваша коллега там в жюри. Да, я уже смотрю, да. Соответственно, я думаю, было бы, может быть, вам интересно и нам поучаствовать в рамках этого конкурса, потому что мы работаем на всю Россию, да, и, в общем, в прошлом году 80 городов, так или иначе, приняли участие, да, и это промо арбитража, мы тоже за арбитраж таковы, ну и у вас есть обучение, ну и вообще, как второе направление, ну и третье, это партнерство в рамках нашего основного, да, у вас здесь, я смотрю, вы тоже об этом пишете и говорите, и, в общем, по крайней мере, не против этого выступаете.
Точно, я более того считаю, что позиция, что не надо что-то что понятно, она опасна, потому что государство это дают и скажут, что это что-то неправильно. Поэтому, мне кажется, вперед какие-то, условно говоря, разрешающие вещи, да, есть.
Ну да, мы тоже по поводу этого считаем, что надо что-то лоббировать, о чем-то говорить, по крайней мере, смотреть, что делают западные коллеги.
Написать правила как раз независимости от системы. Я думаю, что там уже есть смысл что-то, что
инициатива интересная партнерство. Я смотрю, у вас на сайте есть много партнеров. Мы тоже заинтересованы в партнерстве. У нас, в принципе, посещаемый сайт, я думаю, среди всех юридических слов самая большая. С медиа мы справа не можем, после всех остальных, после этого точно. Да, и замечательно. Мы можем с вами как-то, может быть, системно поговорить, как мы можем работать, если у вас нет конфликта интересов никаких? Да, мы покажем, расскажем, да, она
наши правосоветники, занимаются всеми проектами, которые мы делаем.
Прекрасно. Когда вы считаете, когда удобно, когда у вас есть какие-то даты?
Я думаю, что это в районе 20 числа ноября, потому что я эту неделю в Лондоне на Russian Law.
Я тоже туда еду. Будем там, в Лондоне. Давайте 20 числа запишемся, да?
Надо в Лондоне договоримся просто.
Или в Лондоне договоримся. Супер. Супер. Ну, классно. Просто, и еще, ну, соответственно, перепечатывать же статьи можно, да, у нас в медиа, да, с указанием. Я посмотрела вашу часть. Ну, спросим, ну, естественно, с указанием, откуда взяли. Нет, мы сделаем все обязательно, как положено, просто тематика наша. Да, сделаем обязательно. Спасибо. Спасибо.
Я как бы сам арбитраж не делал, но как у нас сейчас признательно, это еще упражняется. Вот признательность. Но они потом приходили. Потом решили товарища прилично попрашивать. Но надо сказать, что эфир продолжается. Я хочу сказать, что там, по сути дела, решение, там решение на, по сути дела, стенограмма заседания, короткая.
So, dear ladies and gentlemen, dear colleagues, please take your seats and we will continue our seminar. Well, the previous session was devoted to the past and present of the New York Convention, and we heard a lot of interesting presentations about problematic issues, practical issues in different jurisdictions. We will try to look into the future, actually, and we will try to predict what will we have in the nearest few years. So we will speak about the future of New York Convention version 2.0. My name is Anton Asoskov. I'm a professor at the Lomonosov Moscow State University. And today we have a very distinguished panel of speakers. All of them are highly reputable practitioners and have many years of experience in arbitration. I will start from my right-hand side. Mr. Andrei Yap, he is the head of international arbitration in the Singaporean law firm Raja and Tan. Then Dr. Xavier Favre-Boulet, he is an attorney at law, and he represents the law firm Lenz and Stählin. And as far as I understand, Xavier is residing in Geneva. And he is also a solicitor in England and Wales and teach law, I guess in the University of Geneva or maybe at some other place. Yeah. Okay. And to my left-hand side, I am glad to introduce Marina Matusekova. She is a partner at the law firm Castaldi Partners. She is an advocate in Paris, in France, and also she is admitted to the New York bar. So I would propose to structure our discussion according to the list of questions which you see now on the slide. And the idea is the following, that yeah, actually the logistics would be the following, that on each issue we have a keynote speaker who will speak for around 10 to 12 minutes. Then each of the members of the panels will have an opportunity to make a brief intervention. And I think I will be ready to take one or two questions or comments from the floor, from the audience after the end of each issue. But I will kindly ask both the members of the panel and the audience to stick to the particular issue which we are discussing and not to go with your questions to the next issues. So we will start with actually exploring whether or not we need, I think we need back this first slide, please. We will start with the question whether or not there are actually any serious problematic issues or lacunas with the New York Convention. So, of course, if there are no such problematic issues, why should we speak about any revision of the New York Convention at all? Then the second issue would be whether we have a problem outside the New York Convention, and namely the activity of different state courts in different countries who also want to attract more and more international commercial cases, and whether or not activities of the Hague Conference on Private International Law constitutes a challenge for the current New York Convention. Then the third issue would be to analyze whether it's feasible at all to speak about any revision maybe of the most successful convention in the human history, because we have 159 contracting states to the New York Convention at the present moment of time. And finally, we will discuss whether we already today have any serious, solid drafts or proposals for the reform of the New York Convention. So it's a quite funny expression, new New York Convention. So whether we already have such drafts, what are they, and do they really represent the viable option? So this is the program for today, and now we move to the first issue about problematic rules and lacunas in the New York Convention, and Andrea will be the keynote speaker on this issue. So Andrea, please, the floor is yours.
First, let me thank the Russian Arbitration Center for the kind invitation. It's certainly my privilege to be here to address this audience. I think most of you would be pretty familiar with the history of the New York Convention and how it started. But essentially, it all goes back to 1923, where there was a protocol of arbitration clauses. And then in 1927, there was a convention for the execution of foreign arbitral awards. And obviously, all these were pre-World War II. After the Second World War, there was a business boom. There was an increase in international transactions. And the big problem was that under the 1927 convention, in order for an arbitration award to be enforced, it had to be final in the place of origin. So that led basically to leave being required to be sought from the place of origin and also eventually the place of enforcement. So that's the double executor problem that was being caused. And eventually, the New York Convention came about, and now we have something like 159 contracting states. So what do we say are some of the deficiencies? I think there's a long list of minor complaints. I'll touch on a few of this and highlight what I think is probably the single most problematic area. And that would be how you deal with awards which have been annulled or have been set aside. But before I go into that, I just wanted to highlight one of the smaller areas where there's some expression of concern relates to the reciprocity reservation which is being permitted under the New York Convention. Basically, Article 1, Sub 1 provides for the scope of the arbitration award and the enforcement. And Article 1.3, 1 Sub 3 basically provides for reservation. And the reservation can be done in two senses. One is to reserve it for commercial transactions or commercial cases. And the second one is really to say that a state is only going to enforce an award from another award from a convention state, basically. And we've got a situation where I think there are like 74 states which have made a reciprocity reservation. And if you look at some states, particularly somewhere like India, for example, they've signed on. They've got a reciprocity reservation. But the way their reservation works essentially is to say that we are going to gazette which countries we recognize and, for which we will have reciprocity. So on their gazetted list, there is something like, only 46 states, which is less than 1/3 of the convention states that we have under the New York Convention. So if we look at this, 7 of the contracting states have made, while making reciprocity reservations, have extended their application to non-contracting states to the extent that those states separately grant reciprocal treatment. So it's a question of how you apply the reciprocity reservations. And I think going from there, the big question that is being addressed today is this something in the past? Are we in a state where we should be going forward and trying to open up more and more in terms of recognizing and enforcing international arbitration awards made under the New York Convention, right? Another point which has been highlighted sometimes is the issue of the lack of a dispute resolution mechanism. As you would appreciate, a lot of determination is left to the national courts of each relevant country. And it could well be that different clauses are interpreted differently in each particular jurisdiction, and there's a question whether it makes sense to have a body that could determine what clauses in the New York Convention should mean. And, you know, there have been different suggestions in this, and there's some suggestion that perhaps, you know, it could be the International Court of Justice or something like that. And in fact, that was in the ECOSOC draft. That's the UN Economics and Social Council draft. This was actually proposed previously, but it wasn't accepted. So that the suggestion then was that if there was to be a dispute, it should be referred to the International Court of Justice for decision. But I think many countries felt that it was an infringement of their sovereignty, actually. And it becomes a compulsory reference to the International Court of Justice rather than a voluntary one. Let me come to perhaps what is the biggest issue today, probably. And this relates to Article 5.1e. Before I go into 5.1e, I just wanted to refresh your memories in relation to Article 5. Article 5 essentially says that an enforcing court may refuse enforcement in certain circumstances, and these are listed in A, B, C, D, and E. So A is basically where there's a situation of incapacity or where the agreement is not valid under the governing law or the seat. B is where there was no due process. C is where the tribunal's composition has gone beyond what was agreed. And another situation is where the award goes outside the scope of submission. And then there is E. And E is where the award has not yet become binding on the parties or has been set aside or suspended by a competent court of the country in which or under the law of which the award was made. Also relevant to this issue of the analysis in terms of whether to recognize or enforce an award which has been set aside, if you look at the decisions, there are typically two other relevant considerations. One is Article 5.2, and Article 5.2 says that the enforcing court can refuse enforcement in a situation where it's contrary to public policy. So if you look at the cases, there's always a public policy consideration. The other relevant provision, which I've not highlighted here, but I wanted to stress, is Article 7. Article 7 actually provides essentially that a party has a right, basically to the extent permitted by law in a particular country where enforcement is being sought, to the full extent of the law of that country or any treaty which that country has entered into. So if there's something that's more favorable to that party, he's entitled to it as of right under Article 7. So there are two issues here. One is how you treat basically an award which has been annulled in the place of origin or the seat of the arbitration. And secondly, what's the meaning of binding? But let me deal with the first one first. So we've put here the New York Convention perspective, the relevant provision there. The Miami draft, my learned friend Xavier will be dealing with that, so I'll leave that for the time being. You've heard about this case. It's Cromalloy. It's a US decision that came about in 1996 or thereabouts. And what had happened was that in that case, the US Court of Appeals for the DC Circuit enforced an arbitral award which had been annulled by the Court of Appeal in Cairo. And the Egyptian court was actually the court of the seat of the arbitration. So traditional arbitration philosophy is that the seat controls everything. And if it's set aside in the seat, then arguably there is no award to speak of. But the US court found that launching an appeal against the award in Egypt violated the final and binding nature of the award. Secondly, they found that failing to recognize the award would violate US pro-arbitration policy. And the position changed, or, in subsequent cases, they departed from this. And, in Termo Rio, the US Court of Appeal in the DC Circuit again framed a relevant inquiry as to whether the foreign court's annulment of the award violated basic notions of justice. And there is another leading case, Commissar against Pemex, where the US District Court enforced an award which had been set aside in Mexico, which was the seat. And in that case, the Mexican courts had retroactively applied Mexican law, which rendered the dispute non-arbitrable. So the court in US held that this was a violation of Commissar's legitimate expectation that the dispute would be arbitrable, and this was a violation of the basic notions of justice. So if we then look at Chromalloy a bit more closely. So Chromalloy was an American company basically supplying helicopters and providing maintenance service for military helicopters to the Egyptian government. Contract was terminated. Chromalloy instituted arbitration proceedings. An award was rendered in favor of Chromalloy. Egypt then challenged the award, got it set aside by the courts in Egypt, and Chromalloy then sought to enforce the award, which had been set aside, in US. And the US courts basically took this position. Essentially, they said that, well, arbitration awards are presumed to be binding and can only be denied effect in very limited cases, such as corruption, fraud, partiality, misconduct, or excess of power. And they went on to hold that since the award was proper and that the arbitration agreement between Egypt and Chromalloy precluded an appeal to the Egyptian courts, the court therefore should grant recognition of the award. So in essence, there was a finality provision in the agreement where parties waived all further appeals. But as we all know, that doesn't usually refer to setting aside or annulment proceedings. That means appeal on the merits, usually. There is another reason that the court mentioned, and which I wanted to highlight, and that is what I mentioned about Article 7. The court said, well, there's Article 7, and for Article 7, you have to look at US law. And the court then went on to look at the US federal arbitration law and concluded that there were no similar grounds of setting aside under US arbitration law. So looking at Article 7, saying, well, Article 7 is relevant, and because of this, therefore, you apply US law somehow or the other, and they seem to be imposing a test that the setting aside had to match what was required under US law. So that's very much the US position. And then there is the UK position. And most of you will be familiar with this. I think the leading case is, of course, UCOS against Rosneft. And the English courts have reached a different decision from that in Maximoff, where the court refused to recognize and enforce an arbitral award that had been set aside in Russia. And the test the English court applied was whether the Russian court's decision was so extreme or incorrect that the courts should not have been regarded as acting in good faith. But frankly, what business has the English court got to do in commenting about whether it's a Russian court or a Mexican court or a Nigerian court, right? So just very quickly, I'm sure you all are pretty familiar with the UCOS case, but essentially there were 4 awards that had been entered in favor of UCOS, and these had been set aside. And despite that, the UK courts went ahead with the enforcement, even though it had been set aside in Russia. Now, what is rather different about UCOS, and I'll come back to this, is that UCOS has no disguise in its reasoning. It has no Article 7 to hang on its case. It just makes a decision that says, well, we have to look at the integrity of a foreign court setting aside the decision. And my question to all of you, is that right? Is that something that should or should not be allowed in a proper sense of today's world? So basically what had happened was that the court says, well, based on the English conflict of law principles, right? In a situation where a judgment has been obtained by fraud, it would be contrary to public policy to enforce the judgment, or if the judgment had been obtained in breach of rules of natural justice. And the court makes that as a principle and then makes a decision. And if you look at the decision, it doesn't say specifically that the Russian courts were either, fraudulent, made something that was typically, contrary to natural justice or anything like that. So basically, the court went on to say here that, well, in giving effect to an award, notwithstanding that it had been set aside or annulled, it would be unsatisfactory and contrary to principle if the court was bound to recognize the decision of a foreign court which offended against principles of honesty, natural justice, and domestic concepts of public policy. Then, very quickly, the French position, and Hill-Martin, again, that's another very famous case. Hill-Martin had basically entered into a contract for consultancy with Onium, and there was a breach of that contract. Hill-Martin sued, and Hill-Martin lost the case. And what then happened was that the other side essentially wanted to enforce the award. And the issue was whether that award could be enforced, given that Hill-Martin had applied to the Swiss court to set aside the award. And the Swiss court had indeed set aside the award. And the reasoning in the French case, in the French court, the Cour de Cassation, essentially is pretty much the same as the US analysis in Cromalloy. They looked at Article 7 and they said, well, if we look at the French Civil Code, Article 1502, there is no equivalent provision for setting aside that is similar to Article 5E. So on that basis, they said, we're not going to enforce, sorry, on this basis, they said that they would still enforce the award even though it had been set aside. Now, just before I go into this, the Singapore Chief Justice Sundresh Menon had, in fact, in a speech given in London for the Chartered Institute of Arbitration at the Centenary Conference on 10th July 2015, made very strong criticism of UCOS. Because UCOS is unlike the French case that we have looked at, Hill-Martin, it's unlike Cromalloy. Those cases at least had the excuse of Article 7. UCOS didn't. UCOS is a decision that criticizes and goes directly towards the integrity of a decision made by the court of a seat of the arbitration, and you are raising questions as to the integrity of that decision. So it's not a question as to, for example, Article 7, where you're saying, well, we don't recognize certain hits, or we only recognize certain bases of setting aside and not others.
Andrea, I would be grateful if in 2-3 minutes
sure,
you can
okay. So
finish here.
taking UCOS to its very logical conclusion, therefore, number one is that it means that you're attacking the integrity of a court of a seat making a decision to set aside the award. Secondly is that you're saying basically that the foreign court that made the award is pretty incompetent. Thirdly, actually, you're challenging parties' autonomy because the parties had decided on the seat. So if you win, you're happy. If you lose, you're unhappy. And it goes back to that decision. So you make that decision and you live with that decision. So the other issue is really in terms of the definition of binding. And basically, it's something that has been looked at in terms of in different jurisdictions differently. I think one approach is that the award is considered binding depending on the law of the award, and this is adopted by the French, the Swiss, and the Italian courts. Another interpretation is that it's no longer open to appeal on the merits, leaving aside issues of setting aside. Thirdly, it's no longer open to an arbitral appeal itself. And fourthly, it's binding unless it's set aside or suspended. So you have different approaches again, and exactly what is binding. The last point I just wanted to highlight is this concept that the agreement must be in writing. And is that good in today's world? In Singapore, we've had a case where there was an oral agreement, actually, and subsequently there were emails just confirming that agreement. And the court actually upheld that position that, well, there was, for all intents and purposes, a written agreement. So that's a $6 million question as to whether the definition here needs to be clarified or modified. So I think those are pretty much the key areas that, that I want to highlight for today's session. And just in terms of the definition of the form of arbitration agreement, there's a suggestion here by the UNCITRAL model law as well. So the next area which you'll hear on, I think, from my colleague Javier towards the end as the fourth speaker is how do we cure all these ills? And we've got Javier here, so please shoot him all your questions, not me.
Andre, many thanks for this exploration of the most problematic issues of the New York Convention. So we see that we do have such problematic issues. So first of all, I ask my co-panelists whether they want to comment on this.
Thank you. I will start with a few comments. I know we have to be short, and of course everything has been said very properly by André, so there is little to add, but nevertheless, I think regarding the so-called reservations, it's typical of the law of treaties that the states liked, especially in the past, to have those reservations, the reciprocity one, the commercial one. But we can be also optimistic. I can tell you that Switzerland, for example, was the first state to withdraw the reservation on reciprocity in 1993, so a long time ago. So it's very political, again, at the end of the day, what the states are ready to make as concessions. Regarding interpretation and uniformity in general, this is the key problem of the application of the New York Convention in the different countries. Today 150 and 59. But as we will see later on in the discussion, there is this UNCITRAL guide on the convention. There is also the ICC, which is working on this, and I think with very serious bodies working on uniformity of the application of the New York Convention, it improved the situation. Also, just because of the transparency, the information that you get about the problems which may exist in certain countries, we try to fix that. The written form, the writing requirements, of course, technically this is a big problem that we have in the New York Convention. It was fixed by that recommendation of UNCITRAL in 2006, but it's a plaster. It's trying to accept that we have a problem in the convention that we cannot really amend, but by the way of our recommendation, we try to avoid the problem. So it's not very serious in a way, but it works. And today, I think the writing requirements are no longer an issue. Don't forget, we didn't have time to address that, but don't forget also Article 3, Article 4, about the practicalities, the procedure in the different countries. There may be difference. This is not harmonized. Sometimes it leads to some problems. In Article 5, of course, I will try to present that with the new draft convention. In Article 5, André concentrated on one aspect, but there are a few others. And just to end with the annulled awards at the place of arbitration and the problem of the recognition and enforcement of those awards set aside, I think it's probably a very good transition for Marina, because to me the most interesting example is France. France from day one has used Article 7 to say, we have a better system than the New York Convention. So what's the problem? We don't need to apply the New York Convention, we apply Article 7. And then there were all these cases, the North Solar case, Ilmarton, Petra Bali, whereas in the US, I think it was more inconsistent because we had Cromalloy, but then we had Baker Marine, Spear, and Thermorio, and more recently we had Pemex. So probably when you have a country where some courts would use Article 7, others would have doubts about that and would not recognize and enforce awards which have been set aside at the place of arbitration, that's very difficult for the clients and for the lawyers in terms of predictability.
Okay.
So could I just say something very quickly on Baker Marine? I just wanted to point it out that in that case, the other side was Chevron, which was a U.S. company, and Chevron was the party that had set aside the award previously.
Yeah, I just wanted to make a very small comment from the Russian law perspective, and I want to remind that unfortunately, yeah, this deals with this issue, what is the binding award? And unfortunately, when translating the New York Convention into Russian, a mistake was made. And in Russian, it is said final award. So not binding award, but final award, окончательное решение in Russian. And this creates a rather huge problem because, as you know, Russian text is also an authentical text of the New York Convention. And that's why if we look into the Russian text, definitely it's not possible to enforce any kinds of interim awards because they are not final. So let's say that Russian text, maybe it deserves improvements, even if we come to the conclusion that everything is okay with the English text and other texts of the New York Convention. So I think I can take one or maybe two questions or comments from the audience, if there are such. Yeah, please.
So I'm Yoshi from Tokyo, and I have perhaps a different view against the evaluation of the present New York Convention. And I think present New York Convention is very successful with 159 the member state because of the very good balance between the harmonization and the real operation of each sovereign state. So if we try to emphasize too much harmonization, and perhaps the next version unfortunately cannot correct such a great number of the member states. So that and I'd like to additionally, for example, the Cromalloy case is I think it's a very healthy reaction against sometimes the emerging market country try to abuse the public policy argument or arbitrability argument of some others. And so the real operation and how can I say the new convention is accidentally the making the kind of the text the interest can be battled the interpretation of the text, and accidentally this is at present very good combination appears, and I don't want to break this good balance, and this is why I'm opposing to the perhaps your views, and which may emphasize too much harmonization. And additionally, one comment is using ICJ for the interpretation of the New York Convention. It might be a nightmare because ICJ judges are good at interpreting the convention which relating to the territory disputes or post-war dispute. But please think about no economic dispute is treated by the judges of the ICJ relating to the WTO matters because they do not know about the real business issue, economic issues, and about the New York Convention is deeply connected to the real economic or business issues. So I think the idea of using the ICJ judges are not so good one. Thank you very much.
Thank you very much for your comments. I'm afraid we need to move forward, and if there are additional questions, you can ask them on a later stage. So we move to the second issue, and namely whether there are any incentives for the reform of the New York Convention which lie outside the text of the New York Convention, and I will make a very brief presentation on this topic. Andre, if I may ask you to hand over the clicker. Yeah, thank you very much. Yeah, thank you. So, we see recently a very interesting phenomenon, which is called international commercial state courts. Firstly, it became quite popular in the Asian region several years ago to establish such types of specific international commercial state courts. And here you see several countries where already such courts are existing. And during the recent, I would say, 2-3 years, this idea became also very fashionable in the continental Europe. And there are undergoing projects, including in France, Germany, Belgium, Netherlands, and some other countries. And I think many of these countries, they try to use a very good moment connected with the Brexit, and they try to push out the English commercial court from the market and to say that there are more convenient and more attractive courts in continental Europe. And we also see that this tendency also evades into the CIS region. And we've heard during the previous panel about the developments in Kazakhstan, and that the same types of special international commercial state courts were introduced there. As far as I know, they even had to make amendments to their Kazakh constitution to organize and introduce such types of special courts. And I very like the citation of a well-known Netherlands specialist in private international law, Bob Wessels, who say that they, namely these kinds of state courts, shoot up like mushrooms after the rain. Of course, in various countries, these state courts have different features, but there are certain similarities, and I've tried to show them on the slides. Namely, specialized judges who should have good knowledge of private international law, comparative law, and deal with foreign law in a professional manner. Then use of English language during the proceedings, which is important in the commercial world. Possibility to deviate from the domestic procedural rules, and what is important in many jurisdictions, also rules regarding evidence and evidentiary hearings. And in some jurisdictions, it's possible even to say that such proceedings, or to establish, to include in the agreement a clause about confidentiality and to limit the opportunities for appeal. Of course, the problem for the state court judgments has always been the recognition and enforcement abroad. And we also see here quite interesting developments. Some time ago, there was a creative ideas from some Asian countries, namely in Dubai to use the, I would say, arbitral clauses. This means that there is an opportunity to convert or transform a court judgment into an arbitral award, and then to try to use the mechanism of the New York Convention in order to recognize and enforce this abroad. But I guess that this type of creative ideas might look problematic, at least for some foreign countries. And I very much doubt if, for example, Russian courts would be ready to enforce such types of converted, transformed court judgments using the New York Convention. Although that's a funny story that there are dozens of erroneous, not correct Russian court decisions in which the New York Convention was applied by mistake to the foreign court judgments, and there are many of them even on the level of cassation courts. But now we see the different situation when we speak about the developments of the Hague Conference on Private International Law and whether or not it can introduce such types of instruments. We should say that historically, Hague Conference was not very successful in resolving these issues. And you see here two conventions which were aimed to create a kind of New York Convention, but for the state court judgments. But both of them were unsuccessful. And there was a draft in the late of 90s, a kind of attempt to copy the Brussels Convention, which was later converted into Brussels I regulation. But again, this project in the late of 90s was not successful, and it even didn't result in any international instruments. But now we have two very important recent developments. The first one is the 2005 Hague Convention on Choice of Court Agreements. And this convention has already entered into force on the 1st of October 2015. And what is important that the European Union has acceded to this convention, and this means that all countries of the European Union became contracting states to this convention. Plus, we have three other countries, namely Singapore, Mexico, and Montenegro. And several states have signed but not yet ratified this convention, including such important states as China and the US. And actually, this Hague Convention, some of the commentators say that it's a kind of minor New York Convention because the same ideas are used in these instruments. And you may see here the citation from Article 8, which actually says that there is an obligation of any contracting states to recognize and enforce the foreign court judgments, and that such enforcement may be refused only on basing on the exhaustive list of grounds. Of course, it's very difficult to read the slides, and I'm not going to do this, but if you try to look into this Article 9 of this convention, you will see that it is very, very similar to Article 5, famous Article 5 of the New York Convention, which again confirms that this convention to a very large extent mirrors the approaches of the New York Convention. And finally, the recent developments, it relates to the draft convention on the recognition and enforcement of foreign judgments, so-called judgments convention, which is believed to be finalized by the next year. And as far as I know, there should be a diplomatic conference next year to sign this convention. And this is an even more broad and ambitious project. And again, we see here that this convention might be a very serious competitor to the New York Convention. And again, it includes the obligation of every contracting state to enforce and recognize foreign decisions, and includes the exhaustive list of grounds for refusal or refusal of recognition or enforcement. And so my conclusion is that if this tendency goes on, and if the state courts get rid of their domestic parochial peculiarities, and at the same time borrow the most attractive elements from the arbitration, plus if they have a kind of their own New York Convention, for example, one of the Hague instruments which I have just mentioned, then such types of international commercial state courts might become very serious competitors to arbitration. And therefore, I believe that arbitration specialists should not rest on their laurels, не должны почивать на лаврах in Russian, and should not ignore the proposals for reforms if they do want to prolong the so-called golden age of arbitration. Yeah, thank you very much. If my co-panelists have any comments, remarks on this issue. Andre, yeah, please.
Yeah, I just wanted to say something. I was actually on the working committee for the formation of the Singapore International Commercial Court. Two things I wanted to make. We didn't see it as competition to arbitration. You know, in Singapore, Singapore had become a major arbitration center before we formed the International Commercial Court. So we saw it not as a competitor, but as a complementary service option for dispute resolution to parties who felt for some reason or the other they just didn't want to arbitrate. And particularly there were some, obviously, companies which had bad experiences with arbitration. Certain states didn't want to, you know, go before arbitrators for different reasons. So those were some of the reasons behind it. Secondly, I think is that I just wanted to pick up the point that in Dubai, what they're doing is that you can convert a court judgment into an award. Actually, I floated that idea in Singapore when we were doing the Singapore International Commercial Court. And the major concern that everyone else on the panel had is that other countries may not choose to enforce it because they see it as a, you know, it's just a conversion act rather than a real arbitral award. But, you know, somehow I think Michael Huang, who's the Chief Justice of the Dubai court, basically decided, well, it's worth a go. So that's how it ended up in Dubai.
Thank you very much, Andrea. Maybe one or two questions, comments from the audience. Okay, yeah.
Thank you very much. And this is Yoshi from Tokyo. And I'm sorry, I have a different view, you know, against your presentation. And first, you know, paying attention to the Hague instruments. And I used to serve as a delegate from Japan for the Hague project. And so the choice of court agreement, the convention, in my view, is only the byproduct of the failure of the very ambitious project in 1990s. And finally, the European countries and the United States could not achieve the consensus, and the project, honestly speaking, braked. But you know, they had to make some kind of the products because they consume the budget and they consume the human resources, and they had to make such kind of the very, you know, the simple convention, because usually the many countries can accept or recognize such a judgment based on the parties' choice of the court agreement without such conventions. So the actual effect of this convention is not so big, in my view. And at this moment, another challenging law-making process, convention-making process is now conducted. But in my view, honestly speaking, the Hague Conference is one of the international organizations. The international organization always have to find another target. Otherwise, they will lose budget. They will lose, their own employees, and they have to lose their jobs. So that they are always chasing the target. And the Hague Convention is now in the kind of the routine and not so productive. And the international...
Thank you very much. So I agree with you that we should not exaggerate at the present moment of time the influence of the 2005 Hague Convention. But if we just imagine that in several years' perspective, the US and China, who has already signed this convention, will ratify it, I think that the situation might be different, and many commercial players may decide that they will stick to such types of newly branded international commercial state courts rather than arbitration. So we should bear this in mind. Yeah.
Can I just make 3 comments? Of course, we can say that those who have taken these initiatives have to be congratulated. It was very difficult. For decades, we had nothing seriously compared to arbitration for the court judgments, only bilateral agreements or regional agreements or rules of public international law, conflict of laws in the different countries. So well done. But the three comments are actually 3 risks. One is this, that we have a sort of minimum result, because we have to find a compromise between the different interests, different countries, and it could be a minimal product. The second risk, I believe, is that there are few states which would ratify this convention. You know that there are many conventions, Hague conventions and others, which were supposed to be a success, and ultimately they were ratified by a couple of countries. So that may be a risk. And third, I would say it may be a matter of education of the judges. Now, let's suppose we have fantastic conventions. Many states ratify those conventions, but we have to apply them. And if you look, if you think about the different courts in all countries in the world, that's not easy to change the mentalities, and so there would be lots of efforts about education. And what I think is extremely impressive in Singapore is that the courts they set up is open to foreign judges. So they welcome trained English judges and other judges from other jurisdictions, and to reach probably the highest level of a sort of local international court. And of course, if we are open-minded and we accept that we have foreign judges coming and that we have a real search for quality, that may work. But I doubt that it will work in many countries.
Yeah, thank you much, Xavier, for these comments. We need to move forward. Again, I'm sorry, but we have a lack of time and 2 presentations ahead, and I have to move forward. And the next issue would be, so if it's possible from the formal point of view to speak about any reform. No, it's not this one. And Marina will speak about possible formal instruments which can be used for resolving this task.
So good evening. I don't have slides because I prefer the view on the sunset view on Moscow. So it's not because I'm lazy. So I've been asked to talk about the feasibility of a revision of the convention, and I will make a step back because I think we should first ask ourselves whether it's necessary to revise the convention. And in asking myself that question, I've tried to go back to facts. And I think there is a consensus today to say that the New York Convention is one of the most successful treaties in terms of number of signatories, 159 states. We'll see how the Hague Convention evolves, but as of today, we don't have any equivalent instrument for court decision. And it's not only the most widely ratified convention, it's, the regime of the convention is also deeply rooted in the legal systems. If you go to see the code of civil procedure of all the countries, contracting parties, well, even the most exotic one, you will see that you recognize the rule on enforcement and recognition. It sounds familiar to you because it's the same pattern taken from the New York Convention. And also, if you look at the actual number, you have to bear in mind that in the vast majority of cases, the awards are enforced voluntarily. So we are talking about, is it 10% or 15% of unfortunate cases where enforcement and recognition proceedings are required. And out of those cases, when the parties seek enforcement, less than 20% have difficulties, and those difficulties often result from the situation of the debtor, lack of assets, or those kind of things, and not from problems linked to the convention itself. So it is a successful tool, I think, and I leave apart the question of contrast with strategical and political interest, and I will talk about that later. And if you look at the survey from arbitration practitioners, well, easy enforcement is one of the main advantages of arbitration, and it's before neutrality, before flexibility of the procedure, before the fact that you can choose your arbitrator. So, of course, the convention is an old text. It could be modernized, but still is successful. And when we look at the problem, often they're not linked to the text of the convention itself, but rather from its application. Because there is a problem of mentality. In some jurisdictions, arbitration is still viewed as something that is derogatory to the normal jurisdiction of courts, instead of being considered as a whole system per se that lies on party autonomy. But even that statement needs to be moderated, because there was an effort in the recent years to collect the case law from all the countries and to analyze it. This was done by the UNCITRAL. And this analysis showed that, in fact, countries apply the convention in a rather consistent manner. So I believe most of the difficulties regarding the convention could be resolved by a mere modern and good faith reading of the text. You know, I'm mentioning Article 2, for instance. Of course, in 1968, they required that the consent. They said that the consent to arbitrate could be exchanged by telegram or telefax. This was what they had then. Of course, today, a consent exchange by email or data message, or now we have the model law specifying, but of course, if you read in an intelligent manner, you can understand that it's valid too. So in the end, the main problem that we have with enforcement today is bias. Okay, and this is where we have those courts in every type of country, even the one with most modern arbitration law, which distorts the concept of public policy to protect local interests. But that problem could not be solved with a revision of the convention, in my opinion, because the state will always be able to find another procedural pretext, no, to protect their political or strategical interest. So the conclusion is that I think the New York Convention is a good text, and it is the result of a compromise, but it sets the minimum standards. And Article 3 is a very good provision in that respect. It sets a principle of non-discrimination. A state cannot impose stricter conditions on the enforcement and recognition of foreign or international awards than it does on the recognition and enforcement of domestic awards. So it set the bottom lines. But behind that, the convention is a very evolutive and progressive text. You know, it's and I'm thinking about Article 7. Article 7 states that the contracting states are free to apply rules that are more favorable than those set forth in the New York Convention. What does it mean? if you have a conflict between the New York Convention and another treaty or a domestic law, you will apply the law, not the one that is more recent or more specific or higher in the hierarchy. You will apply the one that is more favorable to enforcement. So that's a really modern provision that allows evolution of the arbitration system. It's called the more favorable right provision, and it's a powerful tool in my opinion. And this has been used by French law, indeed, in the French system. The fact that an award has been annulled in another country is not a ground for refusal of recognition and enforcement, because we have not reproduced Article 5(1)(e). And another example, in Dutch law, they state that the writing requirement is required as a matter of proof and not as validity of the arbitration clause. And I think that's a power tool to improve the system on the merits. So this is where we stand. We have a text which has some flaws. This is undeniable, but it works quite well globally, and it is open to evolution. So the issue is whether we really want revolution to try to tend to an absolute harmonization, or is that wishful thinking? Now I come to the second part of my presentation, which is what are the instruments if we want to improve the system? And I think there are three possibilities. So first one is a revision of the convention. But it's a huge work, and it's difficult to put in place, it's risky, and if we do that, we really have to be sure that what we propose contains innovative solution, you know, that it strikes a balance with the current system. Why is it so difficult to change the convention? Well, it's very unrealistic to think that we can have an agreement with 159 states, and especially in the current context. You know, today, with the development of investment arbitration, most of the states have developed a very protective mindset, and I'm sure they could take advantage of a revision to step out of the convention. And we have noticed in those last year, a lot of states have terminated international convention on arbitration. You know, Bolivia, Venezuela, recently Italy have terminated, have come out from the exit convention. Russia has come out from the ECT treaty. And even the EU is not favorable to arbitration. If you see, you know, the recent ACMEA decision, it has constrained all EU countries to terminate intra-EU BITs. So what we would have if we try to renegotiate today is probably more people exiting than entering, you know. So I think I would stay with what we have. And also I'm sure that a lot of states would not be willing to maintain Article 7, the more favorable right provision. And I think this is a very powerful tool for evolution of the system. So this is the first solution, a revision of the treaty, which would be very demanding and not easy. Second solution, it's an intermediate solution. We keep the convention, and we propose an additional protocol with amendments. Well, in my opinion, that would complicate things, because we would have a two-tier justice system with two different rules, two types of New York Convention states, and two speeds. And there would be reciprocity issues if you have a case with one country having ratified the new rules and with another having not. Okay, so in my opinion, it's not the good solution, because either you go for revolution or no. So third possibility, it's the model law. And I think it's the, you know, the more realistic approach and the wisest approach. So you lived with the convention, and you use soft law to educate scholars, to educate legislators, to educate judges. So with that, you try to assist judges in applying in a more harmonious manner the convention. And when you have a good set of practice, then you try to incite legislators to improve their local law on arbitration, and that is fully consistent with Article 7 of the New York Convention. And this is the route that is being taken today. You know, a lot of bodies, the ICC, the IBA, the UNCITRAL, are trying to promote a uniform application. And I will mention the UNCITRAL project, because that's the one I'm the most familiar with. So they have created a website on which they have collected more than about 2,700 decisions from 60 countries. Even the most, the countries which do not usually publish their case law, like Iran. And you have the original decision online, it's freely accessible, you have the translation in English, and you also have a summary of the decision. It's very easy to navigate on the website, and I encourage you to visit it. It's nyconvention1958.org, and you may access the decision by country, by theme, by article. And I think this is probably the wisest solution to improve the system, even if it takes longer. And I will conclude by saying that maybe in a few decades, when artificial intelligence will have totally put arbitration upside down, or maybe because we'll be in an even more globalized world, then it will be time to think of a revision. But today I will stick to the text as it is. Thank you.
Marina, thanks a lot for your insights and for this cautious, I would say traditional, in a bit conservative position. If my co-panelists want to add something.
Well, I agree 100%. So I have little to add. I studied the position 10 years ago for the 50th anniversary, and I published an article on this, and I was exactly on the same page at the time, and I think nothing has really progressed in between in 10 years' time. To me, one key word is pragmatism. We have to be pragmatic and not hope about the sort of magical new convention or new protocol. I think all difficulties have been described by Marina, and I think there is a clear distinction these days between soft law. We see, for example, the IBA, among others, adopting new guidelines and rules, but still soft law each year, because it's easy. We believe, we want to fix that, and maybe we have the new edition correcting the first version, and so on and so forth. But here we are with a very formal treaty, with a very large number of countries, and to me, we should stick with what we have, which was a great success. Of course, it's not perfect, but we have to do with it.
Thank you. Perhaps in the audience there are some people who are ready to vote for the revolution and for the radical changes. Any questions? Yes, please, Veronica. Can we have a microphone, please?
I guess I have enough voice.
Yeah, it's here, it's coming.
Okay, yeah. So I agree that making revolution will end in some states, indeed, opting out of the regime of New York Convention. But my concern is that maybe there is no need for revolution, but maybe there is a chance that at least some amendments will be successful, and maybe that some agreement will be made to improve at least a little bit the conventional regime. So why don't try to, have representatives from all 159 countries and just have a big conference, big session, for a month. But maybe it will turn out that they have at least some agreement on some points that at least a little bit improve the regime. Because I'm still young, but I read certain articles also devoted to 50th anniversary, and it was the same view. But for me, it seems like every time, every decade, people just talk about how difficult it will be to amend the convention, but actually maybe do nothing to reach at least, you know, some result, and maybe to amend at least one word, which will make the world better.
Thank you very much. So we see that the younger generation is ready for more radical steps. And actually we move to our final issue and to the maybe the most interesting discussion about the already existing drafts of such types of new New York Convention. And Xavier will speak about such drafts.
Thank you. I'm back again, and the lucky people were certainly in the sun of Miami for the baptism of the so-called Miami draft. I was less fortunate, and I ended up in Dublin, where its twin brother was born. 10 years ago, in June 2008, at the ICA Congress, in Dublin, Mr. New York Convention, as we could call him, Professor Albert-Jan van den Berg, made a very innovative contribution. Instead of merely highlighting the strengths and weaknesses of the contents of the New York Convention, as he had been doing and many had been doing before at the IBA and ICA, then he said that this old star was showing its age and should be replaced. And he even had an example of a replacement ready, a new New York Convention, what he called a hypothetical draft convention, an hypothetical draft convention 2008 on the international enforcement of arbitration agreements and awards, and what others renamed at the time the New Dublin Convention, and subsequently on the occasion of a conference in 2009 it became the Miami Draft. And Professor van den Berg basically said he suggested to add new provisions, to revise existing provisions, to clarify others, and to delete outdated provisions, and to align other provisions with prevailing judicial interpretation. That was the goal of the exercise. But we were not at the end of our surprise in Dublin. After a very impressive presentation of the Van den Berg Convention, other panelists, I was there, made their comments, and among them, Emmanuel Gaillard, a very well-known French professor, and Professor Gaillard at the floor, and he strongly argued against such a new convention based on what he called, I really remember, you know, Professor Gaillard, he said, the three no's. There is no need, no hope, and no danger. So there was a constructive but frank clash of opinions, as it rarely happens at arbitration conferences. And in order to decide who shall be the winner of the contest, one has to first look at the proposed amendments to the New York Convention. I will have to be short, I'm afraid, but that's the game. We have the old one. Yes, for sure. The telegrams, the emails were not there. Would be different in insisting on the enforcement of arbitration agreements and awards. Compare the two. I have each time the new text as such, but it's probably more interesting to compare the current version of the New York Convention and the hypothetical Van den Berg Convention. Briefly, you see that for Article 1, beyond the title, the Miami Draft contains several proposed amendments, and the main goal is to clarify that the Convention applies not only to the enforcement of arbitral awards in international arbitration, but also to an arbitration agreement as provided in Article 2, and the reservations would be dropped. If we move to Article 2, no surprise, the Miami draft would abolish the written form requirements and would redefine more clearly under what conditions a defendant could prove that the court should not refer the dispute to arbitration. So there would be those situations where the court has to refer the matter to arbitration, and then the circumstances where the court shall not refer to the dispute to arbitration. The test about which, and there is an interesting definition you see in Article 2C, arbitration of the dispute, of course, short on certain provisions, we have no time, but Article 3, the Miami draft, again, cannot bring solutions to the absence of uniform procedure for the enforcement. So you may have discovery, you may have different rules in the respective jurisdictions. Each state will apply its own rules of procedure, but there is nevertheless an attempt to say the award shall be enforced exclusively on the basis of the conditions set forth in this convention, and the law of the country where enforcement is sought shall govern the procedure for enforcement of the awards. It's just a distinction between the two. But 3, you see, there shall not be imposed onerous requirements on the procedure for enforcement, no substantial fees or charges. So we should not hinder the enforcement under the New York Convention because of local rules of procedure. Then Article 4. This is quite technical, as you know, about the formal requirements for the documents to be provided. For example, there would be, with the Vandenberg Convention, no longer a requirement for the original arbitration agreement to be provided, only the original award or a certified copy. So I like the idea that he really worked on, which is the bulk of the exercise. The Miami draft would make it clear that enforcement shall be refused if one of the grounds for refusal is proved. The grounds in Article 5 are limitative, and it would even be added that enforcement shall be refused in manifest cases only. You see that manifest cases only in subsection 2. But it's good to clarify that shall not be refused, because there are certain countries, problem of translations again, where it may be refused, and we have to be clear as to the test for the courts. If we go through quickly the various objections, there is one which is slightly problematic in practice, which is the incapacity, which is referred to in letter A at the moment. So that would disappear in the Miami draft, and that would be only a reference to a valid arbitration agreement under the law of the country where the award was made. Letter B, Vandenberg would add the equal treatment, which is currently not in the text. Letter C, that would be about simplifying the language. Remember, C, it's the extra petita, ultra petita issue. And D does not call for particular comments. These are minor amendments about the composition of the tribunal. But then we have letter E about the procedure. so again, this is a bit about a new wording, rephrase the provision, and the question of the awards set aside will be discussed later on. Now, with Article 5, let me just right. With 5.2, you have two objections. You have the arbitrability in letter A, and you have. I should try to be back, but I can't see very well.
It's here. It's here. Xavier, it's here. I mean the device.
So 5, 1, 2, A, B, C, D, F, G. Okay. In Article 5, 2A, the Miami draft would actually drop the provision on the arbitrability, and they would treat that as part of international public policy in the next section, which is B. And B then would be limited to the ground to violation of international public policy as prevailing in the country where enforcement is sought. There would be also a waiver introduced, an express waiver rule whereby the party against whom the award is invoked cannot rely on most grounds if that party has not raised them in arbitration without undue delay after the moment when the existence of the ground became known to that party. So I think it's in line with the current practice that you have to raise the objections, and otherwise you might be precluded from doing so. So the work on Article 5, subsection 1 first, and subsection 2 then, would be significant, and this is probably where we might have some debate if we have to discuss at the political level and diplomatic level whether the states would agree to that. Now, moving to Article 7, the Miami draft would maintain the principle that the convention sets a minimum standard and contracting states are free to adopt more liberal regimes for enforcement. So that's the good news for certain countries. But if we go back now, because in relation to the subject matter of the awards set aside at the place of arbitration, now if we go back to letter E,
it's G here.
G.
This
the award has been set aside by the court in the country where the award was made on grounds equivalent to grounds A to E of this paragraph. So you see, they wanted to address the issue in the following way. They would not allow a court to set aside an award at the place of arbitration with whatever grounds which are absolutely not justified, but if those grounds leading to the setting aside of the awards are the ones addressed in the New York Convention, then the rule would be the award which has been set aside by the court would not be recognized. We can agree or not, but that's the way they propose to do it. There was really a clash between the authors, as you understand, and I have somewhere here even an article by Professor Gaillard, and again he published somewhere the urgency of not revising the New York Convention. So there was a debate 10 years ago, 9 years ago, 8 years ago, because it lasted for a while, about the question whether or not we should do something. That was the Miami draft, which has not really evolved in the meantime. And I think the rest of the initiatives has been covered by Marina. It's different. It's not a new convention, but it's trying to fix the current convention with other tools. There are also some authors like Marieke Paulson coming back to the Vienna Convention on the laws of treaties as to how the New York Convention should be better applied, or a proposal for a dual convention, so it's even worse, because we would have a primary convention actually as to how the courts at the place of arbitration should decide, and then a secondary convention for the recognition in the place of performance. I think we don't have time to cover that. And the conclusions, again, I can be very short because I'm back to what Marina said. It's not perfect, certainly. It's a bit old, but it works. And it's a bit difficult to try to change. Maybe our children or grandchildren will meet again in Moscow in 2058, if not before, to discuss concrete amendments to the New York Convention, but we will not be there. And the question is, should we be blamed for not acting now, for our inaction today? But again, I'm back to my pragmatism. I think we should live with what we have and try to fix the problems locally in the different jurisdictions. Thank you.
Many thanks, Xavier, for this deep investigation of the Miami drafts. I can allow maybe one comment, but please don't forget that you will be a kind of impediment before the reception, which will follow this session. So please, comments.
Try to keep short. I'd like to address my question to the French speakers. Bonsoir, merci d'être avec nous. Just a little question. Marina, you've mentioned that the foreign arbitral award, whether it was annulled, it's not a ground for refusal. And I was wondering about the French legislation itself, whether the grounds for resistant enforcement are broader, for example, comparing with the New York Convention. Maybe you could recite something about from your own experience, and you could just recall the grounds which commonly used for refusing the foreign arbitral award by national courts, for example. Thank you.
In my knowledge, the grounds are, except for these particular things that we don't have in our this Article 5.1e, the grounds are quite similar than the one of the New York Convention. That being said, France is not beyond, judgment for its position when there are political and strategic interests at stake. And there was recently a decision from the Tribunal des Conflits. The Tribunal des Conflits is a court that decides who is competent between judiciary courts and administrative courts. And it decided that when you have a contract with the public administration, then to rule on the enforcement and recognition, it's administrative courts that are competent. It's the decision Ryanair, and it's a very criticized decision because it goes against Article 3 of the Convention, which sets a principle of non-discrimination. Here we create a special regime of control of decision with the French administration. So you know, there is this decision which is quite particular.
Thank you much. So to draw some borderline, I would say that there is a kind of consensus among the panelists, and I think most of the audience, that the existing New York Convention is not that bad. You know, making a kind of analogy to human beings, I don't think we need, because I see that most of the people here, they share our views. And drawing this analogy with human beings, you know, 60 years, it's maybe still quite good age, and at this age a human being can be efficient and can efficiently perform his or her functions. As you know, according to the latest Russian reform, it's even not the age for men, you know, asking to receive some pension. We need to work full time, so the New York Convention would also do this. But when we you know, imagine even not 50 years perspective as Xavier proposed, but 10 years perspective. And when we, in 10 years, will celebrating the 17th anniversary, you know, 70 years for a human being, it's already the time at least to think about a successor to whom these functions could be transferred. So on this note, I would like to close our session, and please join me in thanking our panelists for their brilliant presentations. And we have a reception, as far as I understand, so everybody is invited, and we can continue our discussions during the receptions. Thank you.